Well, thank you for joining us tonight for our latest Viking Views webinar. We'll be discussing a topic that is very important, but one that we want to delay, it seems, regardless of our age. We're discussing estate plans and the conversations we all need to be having about end-of-life decisions. We're living in a very uncertain time right now, and now is really the best time to begin planning our final chapter. Whether you're 32 or 92, they're all steps we can be taking right now. And tonight, we are joined by Lowell Stortz. Lowell was born and raised in Decorah, Iowa. He graduated from Augustana in 1980 and attended law school at the University of Iowa. He began his career shortly after graduation and has been with his firm under various names for almost 40 years, rising to partner at Stinson. He's also served as an adjunct professor at the University of Minnesota Law School, Hamline University School of Law, and the University of St. Thomas School of Law, and is a frequent lecturer on tax and business planning for Minnesota Continuing Legal Education. Lowell, thank you so much for joining us tonight.
You're welcome. I look forward to our chat.
Well, we know that estate plans are incredibly important, and they're important at all stages of life. I know for me personally, my parents now, both of them are recently retired. Well, my wife and I are raising two young children. Can you take us through the importance of estate planning at different life stages?
Yeah, it's a great way to look at this. As we hop into this, one of the things I wanted to cover first is the fact that so many people put this off, that it's not the kind of thing that rises to the top very often. I've done this for over 35 years. For most of my career, air travel was the catalyst. People who would put it off and all of a sudden realizing perhaps husband and wife are getting on an airplane, that made the plan rise to the top because it brought the reality of what may happen in life to forefront, even though the risks are probably less than one might otherwise guess. Sickness of a friend or death of a friend has been a catalyst, and right now COVID-19 is a catalyst, and it's, I think, causing people to just think a little bit about, if not their own mortality, that might be a little harsh, but at least the risk of not being in control. So those are all things that have made this planning a little more front burner for a lot of people, whatever their age and whatever their place in life. If anybody out there happens to be taking notes, if you make big headings, I'm going to spend just a few minutes before we get into a little back and forth here under the context very creatively, who, what, when, and why. So first I'm going to run counter to something you asked, Joel, which was stage of life. I start with some things, it's a who question that everybody should think about, regardless of where they are in life. Who's going to make financial decisions if I go through a period of time where I'm not making my own? That's the sort of thing we take care of pretty simply, actually, in a good estate plan. Who's going to make health decisions? Maybe the COVID-19 has us all a little more alerted to that. And there, when you talk about stage of life, we think that's really when you get up there. In your more senior years, you'll go through a period of time where you're not making decisions. I do a lot of these documents for college-age children. What a lot of us think is that, well, of course, physicians or a health facility will let a parent or a spouse speak on behalf of the person who's got an illness or a medical problem, but under the law, the only person who has the right to speak for you is you, unless you've done a healthcare declaration or living will, sometimes they're called. So I do a number of those for young people as they're going off for college, realizing that they may want their parents still involved and have the legal right to step in. Other issues to think about is who will manage my estate, who will be trustee of any trust. If you're young and have children, who will be guardians for them if this horrible thing happens, almost too hard to think about, that neither parent is available. You should have the right to make that choice, and the kind of planning we do for people allows them to legally prescribe who would be the guardian. Let me pause for a minute on the what. I said I'd go from who to what. All of you have a plan in place. State law indicates what will happen in the event of your death. It's just the plan may not be what you're hoping for in your own planning mindset. The state laws don't do a very good job of helping with tax planning. State laws don't include gifts for charities or other important people in your lives other than maybe children and spouses. The state law is really not helpful for many blended family situations. The laws were sort of, in some cases, passed years ago when they made an assumption, probably even silly then, that every family was a single marriage with children. So taking the reins and doing your own planning as opposed to letting the plan that the state puts in place is really wise. I'm going to take two swings at the when question. A lot of people put off planning because they don't know that it's going to be right. They make a choice today, maybe it won't be right in 2 years or 5 years, and they kind of get stalled on this thought that if I'm going to do a plan, I have to make sure it's durable, that I make good decisions now and that they're going to be good for a long time. I always tell my clients the only time a plan needs to be right is tomorrow. I mean, you really can't predict the future. So on the when question of can I really do this plan that'll last for a decade or two, I have clients who haven't changed their wills in 30 years. We got it right the first time, but it would certainly be a mistake to put off the planning just because you're not sure you can nail all the decisions down forever. And then maybe, Joel, finally circling back specifically to your question about the stages in life, the truth is if you're single and don't have anything, other than that healthcare declaration and power of attorney for financial decisions I mentioned, you probably don't need to worry too much about a will or other planning. But certainly once you have children, planning again to name a guardian or think how assets might be managed for children in the event of death. Middle age, you're accumulating more, probably more tax planning might come into play. And then when we all get up there, we're seeing that now with this COVID-19 data that we get on a regular basis, where we found that some care facilities are actually not hotbeds of spreading the virus and some are. So I think there's a way in which this planning involving not just lawyers, but maybe other professionals in your life and family, you can dig in a little earlier on decisions as to where you might want to be, kind of get a little control over that. The other issue that people might want to think about, I'm not an insurance salesman, it's a personal choice whether you do this or not, but long-term care insurance can really bring some comfort to people who may find the selection of the right facility to involve some costs, and they want to know how they're going to cover those costs. And then I said I'd touch on why, but that's pretty obvious. I think if you care about your family, maybe you care that your church or Augustana College or some other entity will understand that you cared about them, and there might be a gift in your estate plan. If you don't care enough, and if those whys aren't strong enough for you to do your estate plan, then it may be that those that you love or care about don't experience that love through the planning you might do for them. So I think with that overview, Joel, maybe I'll pause a little bit and you may have a question or two, or you can direct me a little bit.
Yeah, I think I'll go with that last topic you talked about. I once heard someone say that when you die, your money can go to 2 of 3 places. It can go to your family, it can go to your charity, and it can go to the IRS, and you get to pick 2 out of 3. But if you don't have a plan, then the IRS is definitely the one that gets to decide.
Yeah, that's a really good way to think about it. Estate taxes, that is the amount of money that the government skims off the top of an estate when someone dies, has become a little less significant. The federal exemptions are very, very high. But depending on the state you live in, there may be taxes that can be avoided for the benefit of your family. And then IRA and retirement plan assets constitute a really large share of many people's estates. And those are income taxable to any recipient except a charity. So there's a way in which, with good planning, you can reduce the amount of tax that, for example, your children might pay as they inherit an IRA retirement plan, or maybe direct it to charity and kind of in those 3 circles you talked about, skip the IRS entirely and move a little more onto the charitable circle.
You mentioned when people have children, maybe they're trying to figure out who would be the guardian should they pass. What about another challenge, and maybe it's for people in the other stage of life as they're looking at retirement, determining which child might be their be given power of attorney or a trustee, and how do you help walk people through those decisions?
That's a really good question. It comes up all the time. You know, if you assume even a somewhat functional family, and none of us come from totally functional families, but if you assume the family gets along generally well, nonetheless, the parents may still never have shared with their children which of them they think maybe has the best business acumen, which of them might be more in line to do the healthcare decision making. But I think what I help them do is see the importance of designating someone. And then there's nothing wrong with having a couple of children, maybe even more, act together. If the family dynamics are that those children can act together, we can set up a structure so that it's not cumbersome, but you're not forced to say, child one gets all the decision-making authority, child two sits on the sideline.
Now, generically, we've heard the term power of attorney, and there's probably even a broader term for that. But can you talk through maybe the distinction and differences between the medical side of things versus the financial side of things?
Yeah, the power of attorney, I've always thought it's unfortunate that it uses the word attorney because it confuses a lot of people. Power of attorney is simply a legal term that creates what's called under the law an agency. In other words, you've designated someone, call them your agent, to make financial decisions for you. Seldom do those decisions need to be made in a huge rush. So I bring that up because if people have their children scattered all over the country, they can still choose the one or two children who seem to care most or be best at business decisions to work under that power of attorney form, even if they're not local. And the real question there is who will pay attention, who will understand financial issues and help when the help is needed. Now, the healthcare declaration or living will, whatever you want to call it, it also creates an agency. You designate who will make healthcare decisions for you. And that one I worry about a little more because there can be times when that needs to be acted upon very quickly. So in those cases, you need to choose the kind of maybe prioritize those children who would have the most time or be available. You want them to be good at it. You want to have confidence in their decision-making authority. And then maybe more importantly, make sure those designated have a copy of that document and maybe even make it a part of your medical record so that we all hope in life we don't face these emergencies. But if we do, that document is available and either a physician or family member will be able to locate it easily.
Now, those of us who aren't attorneys, and this isn't the world we live in, we generically usually just think of a will. So can you take us through maybe the distinction between a will and a living trust and help us understand kind of the importance of all?
Yeah, we'll start with the will. It's simply, I think of it as the game plan or the plan for how the estate will be handled, written document signed and witnessed, and it has no effect until someone has died. And at that point, that becomes the document that gives someone the authority to make decisions on behalf of the estate and lays out the directions to that person about what they should do. That will often needs to be admitted to a probate court where the court kind of certifies that that's the right will, that there wasn't a later will, that it was validly executed, that you can go ahead and operate under that will, and also then gives whoever is appointed to act as executor a paper from the court that will show their authority. That's how many, many estates are handled. As an alternative, if people worry a little bit about going through the probate court, maybe they did it once for an aunt or a parent and it took a long time and maybe they were uncomfortable with it. If you create a trust during lifetime and put your assets into the trust, often called a living trust or revocable trust, you still control the assets. Nothing has changed in terms of tax filings or anything else, but just the way the law works, your backup trustee upon your death or incapacity can step in automatically and carry out the terms of that plan without needing a court intervention. It's a little more expensive plan to put in place, but it may be, especially given the complexity of the assets, it may be a better plan for some people.
I know for many nursing homes and assisted living facilities are things that weigh heavily because maybe we saw great grandparents, something they really didn't like. But also I think it's the challenge of seeing in some COVID seems to be really impacting them, in others not as much. But also I think people see the assets decline rather rapidly as they see an aging parent or grandparent. And so can you talk about maybe ways to try to help mitigate some of those concerns or costs or decisions as people consider nursing homes? Yeah,
I already mentioned one, and I won't go into it in any great detail, but there is a product out there, long-term care insurance, that will pay at least part of the cost. That can really alleviate a lot of pressure on the family, even if it turns out there are significant resources and perhaps enough to pay for the care. It is a product that I think helps the family relax a little bit in those very early days when it's a very stressful time, knowing there's some source of cash that's coming back from that. Don't get me wrong, I'm not suggesting all should own it or nobody should. It's just worth having people take a look at that product. I would say, and listeners, many of them won't like this perhaps because you don't want to give up control any sooner than you have to. But some of my happiest clients have started this process long before it's necessary. In other words, maybe you're 72 or 3 or 4 years old, you're healthy, you're living on your own, everything's pretty good. That might be the time to try scouting out, and maybe some facilities require the waiting list, to just take that step so that you're doing your own research and getting comfortable with what's out there and what's available. I realize that's easy for me to say, although that age bracket is not too far around the corner for me, and I only hope that I'll do what my more happier clients have done, which is start planning earlier and really sort out which of those facilities seem to fit best. And then this is totally non-lawyer, but I think it's true. When you're doing your healthcare declaration, you have to choose someone who will be your advocate, because you may face this as much planning as you do before you're ready. Facilities may change. And what I've seen is that the persons who are living in these larger facilities, who don't have the ability to make all their own decisions anymore, you don't want someone designated who will simply be available to make decisions. You really need an advocate watching out for you. And maybe everybody will say to themselves, well, of course that's true. But I've certainly seen people who have let's say a child selected who's very passive. And I think you want that child to be willing and able to weigh in and push for what's best for you.
Okay, so whether you're in my seat with a young family or you're getting closer to the end of your career, what are some of the first steps as you're thinking, all right, now's the time, I need to make an estate plan? Take me through the very basic step.
I think the basic steps is, I'll pat myself on the back for a minute. It's where I started, the who question. You're going to need some people who you will designate to be executive of your estate, maybe guardians for your children. Start thinking through that carefully, sort of to make the list, even if you can't narrow it down yet. I mentioned, and you, in response to your question, a will maybe needs to be probated with the probate court, a trust doesn't. Making a good list of assets and being prepared to talk to either an attorney, perhaps an accountant, maybe a financial planner about what your assets are is important, because there are some other easy ways to avoid probate court without the expense and hassle of a revocable or living trust. If I own my assets jointly with my children will inherit them directly in the event of my death without any probate. I can name them as beneficiary of IRAs or retirement plans. So it's not all about wealth or what you own, but having that list of assets ready to go over will really help the advisor cue you in. And then whatever it is you have in terms of possessions, when you decide who you'd like to receive them, you have to have a really candid conversation with yourself first about whether those beneficiaries are ready to manage inherited wealth. It's a wonderful, wonderful gift to find out that you've had your own wealth enhanced through a gift or inheritance. But we've all read the papers or seen the stories of folks who weren't ready to handle it, and it can be a challenge to people. And there are structures to build into an estate plan, like a trust arrangement, I won't go into all the details, where money can be managed either maybe along with the input of that beneficiary, so that if they're not astute on financial matters, they've got some help to make sure they get it right along the way. And so maybe preparing for that thought and being willing to be candid with your advisor about your beneficiaries, what makes you feel good, where you maybe see some angst that should be addressed.
So you'd mentioned advisors and accountants. What roles do other outside experts play in addition to the attorney, your financial planner, your therapist, your accountant, your charitable organization, whatever it might be? What does that look like?
Well, the advice I would give to folks who are either doing this or planning to is you probably need somewhat of a team. And by that, I mean, there are lawyers who do the estate planning and file income tax returns and do everything that's needed, but a lot don't. A lot are more specialized. So if you've used the tax preparer in the past, you can assume that you'll want to continue to have a role for that tax preparer, because the lawyer you hire may not do that. When I mentioned a minute ago that people should make a list of their assets, if they use a financial planner at any level, that's just a wonderful opportunity. They're paying for that resource already to have that planner in the loop to present that information in a way that will be readily understandable to the accountant or the lawyer working on this. The insurance people can be part of the team. I suppose the one point I'd make here and then pause again for more questions is your advisors ought to work as a team. If you have a sense that you're going to use more than one and they seem to be elbowing each other out, one wants the work, one doesn't want to share with the other one, you've really got the wrong advisors. Part of the joy of doing the work I do is not just to work with the clients, but it's to have those allied professionals. It might include bankers, pure financial planners, brokers, insurance people, tax professionals, working together and deciding who should take the lead and who can best make the call. It sounds really complicated, and it doesn't take all those people in all plans, but I think folks listening or advising others will know who has a team and who needs one and who can maybe get by without.
Okay. So without naming a person or a family, obviously, do you have one that sticks out in your entire career that you can look back on and you think, man, that was terribly done, or you think they did everything wrong and I wish I could make sure everyone doesn't follow their example?
Yeah, that's a great question. What I've told many people is if you haven't used a lawyer before in estate planning, you should absolutely feel free to interview them because you get their own philosophy, right? None of us can be completely apart from who we are and what we believe in. I always try to make sure I'm doing the client's plan, not what I think is best, but what they think is best. But you still get a little philosophy. So that's my long-winded way of getting to the point. The one I thought was the worst I ever worked on was a person who saw the estate planning process and starting it during lifetime as a way to control the people, including not always people, the charitable entities he was trying to benefit. It was all about, I have this wealth, and what this wealth means to me is control. And it just, nobody was ever happy. It just never quite got there, because as opposed to saying, what do I most want to accomplish? It was really, how will this wealth help me seal relationships, make sure people do what I want them to do? And there can be a little bit of that mixed in, but it's, I think admitting to yourself that at the very end, control is gone anyway, and getting used to letting go of a little of that control along the way is probably not a bad thing. There could even be a little spiritual analysis thrown in that would suggest giving up control is not, some control is not all bad.
Now, you practice in the Twin Cities, and probably one of the most high profile cases in your realm that happened recently was Prince and the lack of any sort of estate planning. Did you discover that once that happened and how it's moved through several different courts, have you seen an uptick on people saying, you know what, I need to get my affairs in order, I need to get an estate plan?
That's really a great question. And I don't mean to make light of it, but the truth is, yes, for about 4.5 days. And then there's something about this planning process. First of all, facing our own mortality, even when you get a stark example like that, it did motivate people for a while. I had the same thing when Jackie Onassis died. In fact, I'd have people call and say, you know that plan they told about in the Wall Street Journal that Jackie Onassis did? Can I do one of those? So you get it for a while, but I find that those high profile events really aren't enough. It's not enough motivation to keep people to task. So maybe we go back to the team, their advisors need to needle them a little bit if they haven't done this work, or family can maybe find a way to talk about that, although that can be uncomfortable.
Now, you'd mentioned some of these high profile ones don't have a huge impact. And I think sometimes we think the court is going to look in our best interest, but we had the case of, was it Terri Schiavo, who had parents on one side, spouse on the other side, no plans. Take me through what that looks like, kind of bring up those conversations with people to make sure they need to have something in place so they don't fall into a similar situation.
Yeah, you don't want to prompt people solely by fear if you can help it. But the truth is, I'll give you one example and then we'll go back to Schiavo. But there was a person who couldn't make her own decisions anymore. And if you have not done any planning, you find yourself unable to make either your financial or healthcare decisions, and decisions need to be made, the only legal remedy is a court-supervised guardianship or conservatorship. And that requires that you actually be brought into the courtroom if you are physically able. At least it does in Minnesota. You have to be at the hearing. You have to listen to your loved ones present testimony to the effect that you're no longer able to handle your own affairs. And then from that point forward, whoever is appointed needs to report back to the court periodically. So it's expensive, it's unpleasant to go through. Whereas had the person simply signed a healthcare declaration, the agent would have been there able to make those decisions on a legal basis, and you wouldn't have required the appointment of someone by a court. Or on the financial level, you wouldn't have needed that. What happened with Terri Schiavo, as I remember the case, is her husband wanted, I may have this turned around, but I think he thought that she should be allowed to die. If I remember, she had some incurable state, and I believe it was her parents who didn't. And nobody has a legal right unless she has signed something to say. So now you're presenting it to a judge and hoping that the judge will align with your views. And that one ended up on national TV, and I can't actually remember why. I don't remember all the details.
So certainly one of the other questions people probably bring up is they're seeing a parent age, they're seeing things happen to their parent, maybe now their parent is widowed. How do you begin to broach those subjects of saying, all right, mom or dad, we need to talk about a life plan. What do you have lined up? How do you do that in a way that's effective without making the person feel defensive?
Yeah, it's a great question. Hopefully, our best results are when either we or other professionals are involved with those other family members as well, where the parents have said it's okay to share some of this, so we become a team, not just the other advisors, but along with those children. And maybe because we don't have to see them on Sunday over Sunday dinner, maybe we can push a little harder. Look, there's no formula. In some families I've seen, it has helped to make absolutely clear up front that it has nothing to do with assets. I don't, if I were a child leading that discussion, if it was comfortable for me, given my relationship with my parents, I'd make clear right up front, I only care that good decisions get made for you. If you want to tell me about financial issues, that's great. But there can be a time when the parents feel like, well, yeah, I haven't seen much of these children lately, and all of a sudden they show up with this new to-do list, and it feels to me like just maybe they're worried more about assets than they are me. So calling it right out at the beginning and really delving into the personal side of it, what's going to allow us to take care of you, and then circling back to the other planning might be one strategy. It's hard. I've seen really hard feelings erupt in all of this, and I guess I'll have to trust everyone listening to know their own family and try to figure out what might work.
Now, certainly one of the changes now versus just a decade ago or 2 decades ago are the electronic passwords that we're keeping now for our financial sites, for social media, for emails, for a whole host of things. How do people make sure that they've got a plan for that, so that when they're passing away, their family doesn't have to try to scramble to figure out, how do I close down 10,000 things, and I have no idea how to get any of that done?
Yeah, that's a really great question. And when we've administered some estates, it's been incredibly difficult to access certain assets, especially if the person, even though getting up in years, felt comfortable with technology, they may have opted for virtually every account to get only electronic statements and to access their accounts only electronically. So first of all, you have to trust someone. Someone needs to know where your list is and where your passwords are, and maybe you can figure out some uber secure way. Maybe you can have 2 people have to coordinate together to get into your safe deposit box if you're really nervous about that. But it saves so much time and money. And then the legal documentation we do, especially in some states, Minnesota is one, there is another page added to the power of attorney form now that specifically addresses and tries to assure third parties out there, banks, brokerage companies, that this person acting under the power of attorney has the right to access those accounts, even if they don't have available all the passwords or other ways that they might get into them.
So one last question. Now, you practice in the Twin Cities. So if someone lives there, they can reach out to you. But what does it look like? You'd mentioned interviewing people. So whether they live here in Sioux Falls, West River, they live in Oregon, wherever it might be, what are some of the steps you take to make certain people pick a good attorney who's, as you mentioned, part of their team versus landing with one that they might come to regret later?
Yeah. Well, we've all got our own styles. Years ago, it dawned on me that I need to find new clients periodically, and I need to invest in that process. So I don't get paid from the beginning. I get paid only when clients agree that I will work with them. So one of my methods is, whether it's in person or over the phone or in today's world, Zoom, to have an initial meeting, if it merits it, maybe even a couple, where they know that if at the end of that time I'm not a fit, they're not going to get a bill from me for that original tire kicking. And it's not because I'm generous. I'd like to think I'm generous, but the reason for doing this is that they relax them. And then our meeting is one where nobody's looking at the watch, nobody's wondering what it's going to cost yet. We're just getting issues on the table. So that's, and I think many lawyers will do that. They don't want to be abused. They don't want to have 6 meetings and never get anything done, but they'll certainly, most of them will want to get to know you a little bit. And if it doesn't work out, that shouldn't cost you anything. And then, like everything else in life, from, I guess, buying a car to whatever else you might acquire in life, using word of mouth. Who do you really trust in your life, and who do they use? Most of my best client referrals come from existing clients or referral sources. It's not folks that I find directly on my own. I sometimes do, but it's folks who have enjoyed working with me. And I wish that were everybody. It's not. But for those who have, they'll say to their golf partner, their neighbor, if the topic comes up, why don't you visit with them? And I think people should ask about that to get a good sense ahead of time.
Well, Lowell, thank you so much for joining us tonight. Thank you for giving your time and helping us understand and navigate the complex world of estate plans. I really do appreciate it. Thank you so much.
You're welcome. You're welcome.
All right. Have a great night.
Take care.